Lord, I can't look galloping, but I'm galloping. I'm galloping, my lord. You won't, I wouldn't necessarily, my lord, inflict on you a little more than needed. No. My lord, I'm only referring to the nature of the arguments with reference to marginal notes, with reference to the proviso, and I'm saying, my lord, that they are completely untenable. But, my lord, there is also something which must be brought to your lordship's notice. There was this 1952 agreement. We all had a summary. We were looking for something more authentic. Then my Lord Justice Gavai rightly said that, well, it has at least been introduced by the Prime Minister of Jammu and Kashmir in the Constituent Assembly. My Lord, this was also introduced by the Prime Minister in Parliament, the 52 agreement. And your lordships, I'm just giving the pages only the pages. It is in volume D9. The relevant pages are 53, 54, D9. My lord. These are parliamentary debates, 53, 54, 55, and 96. Now, my lord, I come to Parate's case.
These are the parliamentary debates on?
On, my lord, the 1952 agreement. There was a motion. It was brought to the House, my lord. It was discussed before Parliament. And of course, my lord, it's a pretty long speech, but the Prime Minister spoke about this agreement, and they seemed broadly at item with what Prime Minister of Jammu and Kashmir said. Now, my lord, we come to 2 points, and I'm finished. Article 3, Babulal Parakh. My lord, Babulal Parathe's case is distinguishable. That, my lord, is to be found in Case Law Compilation 6 at page 124.
124.
Yes. And what is significant, my lord, is Justice Das says in our Article 3, we do not have a similar provision like the corresponding article in the American Constitution that the consent of a state legislature is necessary. This is very important, my lord. This is what Justice Das observes correctly. And now, my lord, if you see the 1954 order and the proviso to Article 3, it is precisely that provision in the American Constitution.
You are at page?
Page, my lord, 121 at 124 in volume C6. And then, my lord, I now deal with one point quickly, which is privy purses. My lords, there is no analogy between privy purses in this case. Privy purses, my lord, is a case of ex-rulers. Here, my lord, sovereignty passed on to the people in Jammu and Kashmir already. And even the judgment, which has been relied upon very heavily, my lord, which is Raghunath Ganpat Rao's case in volume C7, 537 at 562, my Lord Justice Pandian speaks glowingly about one basic feature of the Constitution called political justice, political rights. political justice and political rights, Justice Pandian says, has not been touched by the Constitution 26th Amendment. Well, on that very passage, I rely upon to say, in our case, what we are dealing with, my lord, is not only the Constitution, we are also dealing with the class of rights which have been guaranteed to people in Jammu and Kashmir, both under the Indian Constitution and the Jammu and Kashmir Constitution. I would therefore, my lord, respectfully submit that the outcomes of integration, my lord, have been achieved. We may have different perspectives on it, my lord, but we are now only dealing with the validity. And my lord, 356, with very great respect, my lord, is never intended to use for the purpose of usurping state legislatures as bodies ear nominee by Parliament. No, my lord, it cannot be done. That notional vesting of power, my lord, is limited for a small purpose under 356. 370, my lord, is not a purpose which is intra-virus 356. It is alien to 356. And in any event, my lord, 370 says, notwithstanding anything contained in the Constitution, which gives it a certain degree of immunity. My lords, any questions? I'm ready.
Thank you. Thank you, Mr. Subramanian. Thank you very much.
You.
Mrs. Zafisha?
May it please the Lord. It's a pleasure to hear, Lords, the counsels on both sides on various controversial issues which have arisen in the case. What I see is that several issues have been raised in this matter, and the court ultimately is to decide whether this CO 272 and 273, whether they're constitutionally valid or invalid. That would be the direction of the court, and that would be the ultimate decision of this court, whether they need to be sustained or quashed. While making the submissions, Lords, the councils have made at a different level of abstraction as to what possibly could be the grounds on which these two orders can be quashed. My approach would be to go on more fundamentals, the basics of it. The first premises, which to my mind is extremely important, is the existence of the state of Jammu and Kashmir at one point of time in history, and the formation of the Union of India at the same time in history. While as India was being unionized, Jammu and Kashmir state by itself was not a part of India, neither it was a part of British India. Now we have it clear from the various statutes itself, whether it's Government of India Act or whether it's Indian Independence Act, that state of Jammu and Kashmir not being a part of the Union of India at that point of time, nor was a part of British India. It was altogether an independent state. It had its own king, it had its own country, and it had its own laws. The king at that point of time would run the affairs like any other king of any other princely state would do. And the king of the state of Jammu and Kashmir, I will not go back too much in the history, also had certain laws which governed the running of the government. Either the state subject definition, which was introduced way back in 1927 and 1932, which applied only to the people who were residing in that state. Or from time to time, as has happened in all countries of the world, there have been changes, democratization has taken place, And ultimately, the Constitution Act of 1939 was also promulgated by the king. And he created certain institutions in them, supposed to be democratic, but at the same time, he retained all the sovereign powers with him. This was the situation with us. Now, when instrument of accession executed, the circumstance in which it was executed have been already said. They are evident from the letter of 26th October 1947. What is the nature of that instrument of accession has already been read. What was retained and what was transferred or donated to the Union of India. And the subsequent letter of the Governor General dated 27th of November 1947 has also been read, saying that we'll put it to the people of the state whether this instrument of accession is acceptable to them or not. These are facts of history. Having said that, thereafter, after 26th of October 1947 till 26th of January 1950, we have no other document evidencing as to the relationship of the state with the union, except this instrument of accession. What was sought to be stated by the respondents was that there was this proclamation of 25th of November 1949. The Constitution of India itself was adopted on 26th of November 1949, a day before. That has also been read today morning, and it was read earlier also. It said nothing except that the Constitution of India, as may be applicable to the state, would be acceptable to us. At that point of time, it was the successor of the king who was in chair, holding the position of the Maharaja. So when the Constitution itself was being debated, that's again historical fact. What happened in the Constituent Assembly, who said what, may not be relevant, but ultimately the decision of the Constituent Assembly was this, that they to have Article 370 for state of Jammu and Kashmir. To me, this decision appears to be the most significant and important because it answers several other questions. Why for Jammu and Kashmir? Why can't we remove it today in 2023? What is so great about Jammu and Kashmir? If it is a part of India, why should it have a separate constitution? Why should it have a separate flag? Why should the President of India have to concur or consult in the matter of application of laws? These questions are answered by the Constituent Assembly itself, by the debates of the Constituent Assembly itself, and by the very existence of Article 370 as well as very existence of the Constitution of Jammu and Kashmir. Now, this is a fact of history. None of us can alter this fact of history. That is, in my opinion, the premises of this case. And as we proceed further, we find that this basic premise has continued over the years. Now, it's a separate question whether it can be done away with. And if so, in what method, by what procedures, by what process? That's a separate question altogether. The first is, as I would submit for Lord's consideration, this fundamental premise that the state of Jammu and Kashmir was different, Union of India was different. They agreed to join hands, but on certain conditions, which conditions came to be incorporated in terms of initial instrument accession, set later on by the Constitution of Jammu and Kashmir, as well as by the Constitution of India. Now, well, there was another factor. That was the matter went to United Nations and resolutions were passed. Those are also parts of your Lordship's Constituent Assembly debates. Well, these matters were pending. The issue is this, that state of Jammu and Kashmir and Union of India agree so far as the integration. When I'm using this word integration, I mean in the sense of Article 1 of the Constitution of India, as well as Section 3 of the state of Jammu and Kashmir. While that stays, but I, the state of Jammu and Kashmir, should have the power to regulate my own affairs, accept what I have given to you. This is what I'm in condition to that. So in instrument accession, I gave you something. I gave you defense, foreign affairs, and communication. I gave it to you, make laws for it. But for remaining, I will make my own laws. Now, this was the position in 1950. If I put it differently, I had the ocean of, now later on today, we call it now constitutional autonomy. ocean of autonomy available to me in 1950. This is also a fact of history and an important premise in this case, that this position is accepted both by the Union of India as well as by the people of Jammu and Kashmir. I would also like to say something.
I believe, I just wanted to point out, look, we have referred to the history, we have looked at the
I
counter
was saying
viewpoints.
the premises only.
But the fact of the matter is, ultimately, when the constitutional document is drafted and adopted and applied by the people of India, and we, the people of India, include the people of J&K, they're not separate from them.
Yes.
We are part, there will be, obviously, in people of India, there will be people from Punjab, there will be people from Gujarat, there will be people from J&K. Now, the only issue, that may not really be, because we have moved with the passage of time, we have to move with the passage of time.
We have moved. That's what I'm saying.
We
I'm
have
coming to
moved.
that. Yes, I understand.
And
My
now
lord's
the
anxiety
question today is,
whether-
really speaking, is the second part, which is Article 370, which is the main constitutional challenge before us. So let's confine ourselves to that.
It's a question of how the court is viewing the matter. Firstly, we are viewing the matter in a historical perspective, which becomes the foundation of this relationship between union and the state. Well, later on, over these 69 years, have this relationship moved closer? Has this relationship moved forward? And whether there is any possibility in 2019 that we could have done away with the relationship in a sense that Article 370 would go, Constitutional Jammu and Kashmir would go. Have we reached that stage or not? That I will indicate a lot.
We'll continue after lunch, but at lunchtime, the remaining council may please ration out time so that we are done by 4 o'clock this evening. No further now rejoinders, please.